Okay, then, Your Honor, the only other motion that's on the docket for today is my motion for Your Honor to consider attorney's fees. Your Honor will recall, we tried this matter over a series of 5 days, starting in August of '24 and finally ending in August of '25. And during that period of time, we were able to reach after testimony, we were able to reach an agreement on property division. And then we proceeded on the issue of adoption of a parenting plan. Both parties had requested attorney's fees. Your Honor took it under advisement after the August hearing and then issued your order in September. And what we are asking, Your Honor, is we have filed a motion requesting that the court assign attorney's fees and extraordinary fees, particularly the guardian ad litem fee, and also a mediator's fee. Your Honor will recall, I'm not going to belabor the points on doing it. I would just request that if the court considers an award of attorney's fees, that I be allowed to submit my hourly billing, and Your Honor determine which portion would be attributable. Particularly on the mediator's fee, Your Honor, you recall we went to mediation one time. We came back to court. This was when Mr. Bates was represented by Mr. Potter.
That's where he fired Mr. Potter?
In the middle of mediation, he fired Mr. Potter. We went back to try to resolve the mediation. We tried to resolve the property issues, and so we incurred an additional mediator's fee and time at that. And Mr. Bates became disheartened with Mr. Potter and because of certain issues that he fired Mr. Potter, and so that mediation should necessarily be attributable to him. Your Honor will recall that this matter originated with Mr. Bates with the criminal matter. He started out supervised visitation. We went through counselors. We came to court on, I believe, 5 different occasions for the court to expand his visitation with the children. And as a result, he pled guilty on the domestic assault. He completed a anger management. He did that. Those charges, based on the agreement with my client, were expunged from his record. And again, it's a scenario where there is an alimony award. In this case, obviously, he has a significant higher earning capacity. And Your Honor, the underlying criminal contempt matter that we've just arraigned him on, you will recall that Mr. Bates, during the pendency of this case, was supposed to deposit funds into the account. He was supposed to account for all his business dealings, and lo and behold, we find out that Mr. Bates created a secret account and paid cash for a piece of property which he purchased in his own name. He testified that he expended an exorbitant amount of funds to remodel and to build a home, to do things on that property during the pendency, all without the court permission. Those were not disclosed in discovery. That was all testified to at the hearing. And again, it's just our request, Your Honor, that Your Honor consider an award of attorney's fees on behalf of my client. I was handed today, right before Your Honor took the bench, a response that apparently was filed this morning. And again, the sum and substance of the recitation of facts is, Ms. Anderson said it's correct that attorney's fees in divorce cases are considered as spousal support and considered as an alimony award. And again, as she sets forth in her response, the factors set forth the total amount of the attorney's fees and whether the attorney's fees are reasonable, and were they necessary. Again, Your Honor will recall, we took up the better part. This case originated in 2022, and we took up virtually every time Your Honor was on the bench from 22 through 25. This case was on Your Honor's docket at each month that you were in Dixon County on these issues. And we would request that Your Honor allow me to submit my affidavit of fees and extraordinary expenses, and you consider an award.
Ms. Anderson?
Your Honor, I had filed a response. I wasn't sure if you had a copy of it.
I just looked at it in the file. I had not seen it until a moment ago.
I filed this response requesting that the motion for attorney fees be dismissed. I believe that the motion that's been filed is untimely. We had a trial where there's an order that said we were supposed to pursue attorney fees at trial. It's in an order signed by Your Honor. There was no evidence presented at the trial. Ms. Bates had the opportunity to ask for attorney fees while we were here. As Ms. Roberts had said, we were here for 5 days. I know they all weren't full days. A couple times people had gotten sick or whatever. But we were here for 5 days, and she never once brought that issue before the court. It's now been almost a year since the party's last hearing date. I would direct Your Honor's attention to the order that you signed on September 15th. We had completed about 2.5 days of trial, and we had settled the entire case with respect to alimony, property division, primary residential parent. Everything was settled. That you signed that on September 15th, 2025. And in that order, we agreed, we announced it in open court. Mr. Bates agreed that the mother, Miss Bates, was going to be the primary residential parent, and the only issue that was left was the residential schedule, like decision-making, who was going to get tax deduction, and things like that. And in that order, it says that each party reserves the right to request attorney fees at that time. We knew we were coming back on July 31, 2025 for the next hearing date. And we came back on that day, July 31, 2025. There was no evidence presented. We needed a few more hours of trial time, and we came back on August 15th, and we finished up the case that morning, and there was no evidence presented during that whole entire proceeding. So I believe that this request for attorney fees now is untimely. They had the opportunity to present this during the trial, and they sat on the rights and didn't do it. You've already signed an order dated September 15th, 2025, telling the parties if they want attorney fees, bring it to Your Honor's attention on July 31, 2025, which they did not. It's been over a year since that was filed. And I know that, it is in your discretion that you may award attorney fees. There's actually a statute on that. It's under 36-5-103. It talks about attorney fee awards, that they may be awarded, that Your Honor has discretion. But if you look at Section C of that, it talks about a prevailing party. And a prevailing party in a contempt issue, in an enforcement issue, and if you want to alter parenting time, if you want to change custody. No, we'd already determined that the mother's going to have custody. So the issue that was left to be resolved on that last day and a half was just the father's parenting time and who gets the tax deduction and how much the child support was going to be. And the issue of the primary residential parent wasn't even on the table. So I'm just asking that this request for attorney fees be dismissed. Because Mr. Bates should have an opportunity, if you're going to open this back up again, to look through this so that he can object to it, and he also asked for his attorney fees. And I would just point out that some of the issues that were left that last day and a half, he got what he asked for. He got a tax deduction for one of the children. He got expanded parenting time on the weekends. He got more time in the summer. The mother only wanted him to have 1 week in the summer. You gave him more time. So he had issues that were valid before the court. And I think that the issue now to bring up is completely inappropriate. On the other issue, the guardian ad litem fees, you can look back in the court's file. The guardian ad litem was appointed in March 2022. And there's just one sentence, it's paragraph 7, it's numbered 7, that Mickey Smith Esquire is appointed guardian ad litem for the party's minor children. Rule 40A wasn't followed. It should have said how much it was going to cost. It should have set her fee. It should have told them how much they were going to be putting into the clerk's office. And right before the final hearing, you're supposed to let the parties know how much this is going to be. So she did a great job, and she was in the case for 3 years. She sent us an affidavit in December, and it was, I may be making this up, it seemed like it was several $1,000s. So as soon as we got it, I had my client pay half. I said, just go ahead and pay half, and we tried negotiating, a settlement on that. But now, Ms. Bates doesn't want to pay her half.
After years of courtroom battles, the mother's attorney asked the judge to make the father pay thousands in legal fees, claiming he dragged the case out and hid financial information. But the father's attorney argued the request came far too late and should be thrown out. Now the judge must decide who pays the massive legal bill. What do you think? Comment below and subscribe for more courtroom drama.
So I also believe this guardian ad litem issue has a little bit of problems because the original order that appointed her did not talk about fees. It didn't follow the Supreme Court Rule 48, which is supposed to advise the parties what their financial burdens are going to be, but to surprise them years later with this huge bill saying you owe now this guardian thousands of dollars. It's completely unfair now and unjust for Mr. Bates to have to pay this. He did go ahead and pay half of it, and I'm just asking, if you look back at your file, the amount of assets that each of these parties were awarded, their marital estate was well over $1 million. Miss Bates got half of that. She has the ability to pay this money to the guardian ad litem, and it would be extremely unfair now, 3 years, 4 years after her appointment, to have Mr. Bates have to pay all of it. And we're asking that you just order they pay it in half and that you dismiss the attorney fees request now at this point. Thank you.
I would just Bates filed, the provisions that he asked for. He was basically asking for a 50-50 residential schedule. Your Honor's hearing, again, on the order that we entered on September 15th of 2025, it specifically reserved parties' right to request attorney's fees. There was testimony as to that she had retained me on the case and the hourly rate. Again, Your Honor took it under advisement. We did not know what was going to transpire from that. Your Honor then made in the order of September 5th, Your Honor made the specific statement on page 3 of 11. Since the parties are unable to agree, this court is required to provide a parenting plan set forth. I mean, Your Honor found they were not able to agree on anything. The stipulation at the beginning that she was the primary residential parent was done from the beginning, but argued that he should have equal time based on the court's prior evidentiary hearings and the testimony of the therapist, Ms. Pate and Ms. Morton, and the recommendation of the guardian ad litem, the court's own observation of the parties' demeanor and credibility. The court finds that an equal residential schedule would not be in the children's best interest. So we were arguing over substantive matters, Your Honor. It's to come in and say, oh, we stipulated one part of a parenting plan and therefore there was nothing to litigate. But the devil is in the details, as Your Honor knows. We litigated every aspect of that parenting plan. The final decree did. Mrs. Kelly Jo Bates is awarded an absolute divorce on the grounds of cruel and inhumane treatment, also known as inappropriate marital conduct. And again, that was the request that was made. She was victorious in getting the divorce. She was victorious in getting named as the primary residential parent and had to defend vigorously the schedule that the court finally adopted. So again, Your Honor, and as far as the attorneys, as far as the guardian ad litem fees are concerned, they were reasonable and necessary. I can provide the court a transcript if necessary about the appointment. It was my understanding at the time, and again, I didn't pull that because again, I did not, even though this motion for attorney's fees has been filed since December, I did not receive Ms. Anderson's response until right before Your Honor took the bench, and on the appointment of the guardian ad litem. It was my understanding, and again, my thing is that Mr. Potter, his attorney at the time, stipulated and agreed that would be appropriate. And so, again, I'll have to go back and review the transcript on that. So I don't have an independent recollection. I do recall during the pendency of this that they continued to file motions to expand
Well,
his
I'm going
residential
to,
time.
basically, I understand Ms. Anderson, but at the time that the guardian ad litem was appointed, both parties were in agreement with it, and there was no objection made by Mr. Bates's lawyer at that time. In fact, I think both parties were more than willing to allow Ms. Smith, who has long served as a guardian ad litem in these kinds of cases before this court, and her fee schedule was known to both Mr. Potter and Ms. Roberts. So this court is of the opinion that the guardian ad litem's fees were reasonable and should be approved. However, I do find that they should be split equally between the parties, and that Ms. Bates should pay her half because that was the agreement that was made at the time. It may not have been an agreement, but that's tacit in this court.
Yes, Your Honor. And again, I would say, Your Honor, that the evidence was clear at the court that Mr. Bates used the marital funds through the company Infinity Builders. And we produced checks at the hearing where I know at least one occasion he paid $25,000 to Mr. Potter using joint funds that my client did not have the benefit of. And then there was additional payments that were shown in the bank records that he paid Ms. Anderson through business funds. And so, again, it's a scenario where the entire lifestyle of Mr. Bates was funneled through, and he was able to pay his attorney's fees as they went. And he paid Mr. Potter and Ms. Anderson through marital funds, and that was through the business that he was supposed to be putting into the account. So Mr. Bates paid his attorneys, and
This evidence was never brought, which is when it should have been
we,
brought. And now here we are. Relevant statute goes back.
Well, I understand you're objecting, but let's let Ms. Roberts finish her argument, then I'll give you that opportunity.
Your Honor, it was brought up at trial. We submitted the documents, and I asked him particularly at trial. If Ms. Anderson doesn't recall that, but we did go through those documents and show
My
those at the
recollection was
hearing.
that there was an issue about Mr. Bates using the corporate or the business accounts to pay personal, including some portion of his attorney's fees. Now, Ms. Anderson, if you want to address what you were saying.
This motion was brought under Rule 54. Rule 54 has nothing to do with attorney fees. That can do discretionary costs, guardian ad litem fees. This is a totally separate issue. This is under 36-5101H. If you're going to look at an attorney fee award, you have to look at the factors enumerated. So you have to look at the total fees incurred by both parties in the case. And you have to go through all these factors, which party has the ability to pay them, whether they're reasonable. We have to have a trial over all of this. And I've never even seen the affidavit, so I don't even.
She hasn't submitted an
I
affidavit.
know. It
And
seems like
what-
if you would have filed it in December, you would have sent us something, but I haven't seen anything, so.
If I understood Ms. Roberts, her motion is to be allowed to file an affidavit, which she has not yet done, so.
Well, I thought her motion said just she wants to be awarded attorney fees, just like that, under Rule 54, which isn't the right rule. I also feel like this issue has already been put in the court's order. You already spoke to this. They were supposed to bring this to the final hearing. You signed it in September saying, if you want to bring this issue of attorney fees, bring it up at the final hearing, and they did not do that. We were here all day on July 15th, and then we came back in August. They did not do that. They left the building and sat on that. And then they waited until December and said, oh, we need our attorney fees, and they filed a motion under Rule 54, never sent an affidavit for us to even look at, and here we are 5 or 6 months later for something that should have been done a year ago. And I'm just asking that if you found that it's untimely and that they didn't file it during the hearing and that it needs to be dismissed.
All right, your motion to dismiss is currently going to be overruled by the court to the extent that I'm going to allow both sides, if you choose, to submit your affidavit of attorney's fees. I will take this matter under advisement to be able, because of the multi-days that I had to deal with this case in trial, it is not, and it's been some time, it's not as fresh as what I would like to be able to rule on this. I need to review the file and my notes. So we'll take it under advisement. Both sides have 30 days to file any affidavit of attorney's fees that they wish to. I've already ruled on the guardian ad litem fee. All right.
Just when it seemed this years-long divorce battle was finally over, another fight erupted, this time over attorney fees. One side argued they deserved compensation after years of hearings, failed mediation attempts, and hidden financial dealings, while the other claimed the request came far too late. Then the dispute shifted to the guardian ad litem fees, with arguments over who should pay the massive bill. After hearing both sides, the judge ruled that the guardian ad litem costs would be split equally between the parents. But the battle over attorney fees isn't over yet. Instead of making an immediate decision, the judge ordered both sides to submit detailed billing records within 30 days before issuing a final ruling. What do you think? Should one side pay the legal fees, or should each party cover their own costs? Let me know in the comments, and don't forget to like, subscribe, and turn on notifications for more courtroom drama.